people involved. So overall, it is to make sure that our legislation is delivering the intent of the policy. So I support this bill and commend this bill to the House. Thank you, Mr. Speaker.
I call Iain Lees-Galloway.
Thank you very much, Mr. Speaker. It's my pleasure also to rise and speak in support of the Regulatory Systems Workplace Relations Amendment Bill, one of 3 Regulatory Systems Amendment bills that we are considering this afternoon, and which have drawn support from around the House. I think this contribution, Dr. Clark, will be a little bit more substantial in length, if not in quality, than the previous contribution. So this is actually this Regulatory Systems Workplace Relations Amendment Bill, which was the one of the 3 that was considered by the Transport and Industrial Relations Committee, of which I am privileged to be a member, is actually quite an important piece of legislation, and it's become more important as a result of its visit to the Select Committee than it was before it arrived there. And I say that not to suggest that that's all a credit to the excellent work of the members of the committee, although we did try very hard. Actually, the officials identified areas where we could improve both the Employment Relations Act, which is what Part 1 of this bill does, and we could improve the Parental Leave and Employment Protection Act, which is what Part 2 does. So we should be very much appreciative of the work of the officials who supported us in considering this legislation, and frankly, working people will be better off as a result of the gaps that the officials identified. Now, regulatory systems amendment bills are generally fairly technical in their nature, and they do not represent a significant policy shift. They are designed simply to make sure that the principal legislation actually operates in the fashion that it was supposed to operate it. These are tidying up technical errors actually in the legislation that mean that the legislation does not operate in the fashion that was intended by Parliament when the legislation was originally passed. I've spoken previously, but I do want to cover one more time the changes that were recommended by the officials at Select Committee to the Employment Relations Act, because those changes pertain to the very few opportunities that a working person has to take a personal grievance when they are subject to a 90-day no rights at work, fire at will trial period. Now, these trial periods are an affront to people's natural justice. You basically have no rights for the first 90 days that you are at work if you are subject to one of these trial periods. And therefore, we need to ensure that anybody who is subject to one of these periods absolutely has their rights, the few rights that they do have, very, very carefully enshrined in law. Now, when we as a Parliament rightly passed the Employment Standards Legislation Bill last year, which got rid of those odious zero-hour contracts, we added 3 extra provisions to the Employment Relations Act under which an employee could challenge their dismissal under a 90-day trial period. However, unfortunately, what we failed to do as a Parliament at that time was to correctly cross-reference the additional provisions to the part of the bill that actually deals with 90-day trial periods, to make it clear that a person dismissed under a 90-day trial period was able to seek recourse for a dismissal under any of those purposes. So what it meant was that it's possible that without making these amendments in this bill, it's possible that it would have been more difficult for an employee to challenge their dismissal under a 90-day period to lodge a personal grievance under any of those provisions. It's not entirely certain, and in fact we are not applying this retrospectively, because the advice that we receive from officials is that the unjustified dismissal provision is sort of a catch-all, and that any worker who is dismissed for any one of those additional reasons would have been able to take a personal grievance as it was an unjustified dismissal. But you know, it's a sort of belt and braces approach, I suppose, in the legislation, which is important when you're dealing with a situation where people's ordinary rights have been dismissed. Not just diminished, but dismissed under this legislation. And as the Employment Relations Authority has correctly judged, the application of a 90-day trial period and the application of it in the law we need to adhere word for word to the law as it is written and as it was intended by Parliament. So. Small, but in this case, incredibly important changes to the legislation. There are also the original changes to the Employment Relations Act, which continue to be supported by the House, ensure that to ensure that the provisions relating to breaches of the Employment Relations Act and to ensure that the responsibility for a breach of the Employment Relations Act falls where it is appropriate, and that is the policy. The policy purpose was that an officer of a company or a partnership or limited partnership or sole trader would be the person, senior people who actually have responsibility for the running of the organisation, the people who are responsible in the event that that entity breaches any part of employment law, and it's just tidying that up to make sure that that policy is appropriately implemented. Part 2 of the bill relates to the Parental Leave and Employment Protection Act. Again, an additional change was raised by the officials, and that was to ensure that anybody who comes back to work as part of a keeping in touch day. So we've added this new idea of keeping in touch days, where someone who is on paid parental leave can come back and do a little bit of work, or maybe come back for an important meeting that's occurring at work, so that they can keep in touch with their workplace while they are on paid parental leave. And they can work up to 40 hours whilst they're under paid parental leave. If they work over 40 hours, then they are deemed to have returned to work and they lose access to their paid parental leave. Now, unfortunately, we left the word paid out. And again, there was potential there for someone who came back after the paid parental leave period was finished and worked more than 40 hours, would lose access to their unpaid parental leave, because obviously workers have, beyond the paid parental leave that they receive, they can then have up to a year of unpaid parental leave. And just the way the legislation was worded, there was some possibility that working more than 40 hours during that unpaid parental leave period would then cause the employee to lose their right to unpaid parental leave. That was never the policy intention, so we have inserted the word paid, one word, and it makes an awful lot of difference to the implementation of the policy. Again, the original changes were in relation to when a person receives a payment when they have had a preterm baby. This is a new provision in the legislation, which was also made as part of the employment standards legislation. And this was part of the deal done between the ACT Party and the National Party when Sue Moroney's bill to extend paid parental leave to 26 weeks did actually receive the support of the House, but was subjected to a financial veto by the then Finance Minister, now Prime Minister Bill English, against the will of Parliament. Part of the deal there with the ACT Party is that there would be additional provisions for people who had preterm babies. We didn't quite get the wording correct, and this bill tidies that up. So some small but meaningful amendments to our employment legislation, sir, and for those reasons the Labour opposition is very, very happy to support this bill.
Members, the question then is that the Regulatory Systems Building and Housing Amendment Bill now be read a third time. Those of that opinion will say aye. Those against no. The ayes have it.
Regulatory Systems Building and Housing Amendment Bill, third reading.